has been held to be procedurally unconscionable.
Well, but counsel, what about due process? I mean, to have a dispute with somebody who's the one deciding the dispute seems like there might be a problem there.
Yes.
Before I say that, it's now in session. Honorable Chief Justice Cadish presiding.
Go ahead and have a seat, everybody. All right, good afternoon. We are here for argument today on case number 85527, National Football League and Roger Goodell versus Jon Gruden. Is everybody ready to proceed? Okay, great. And help me with how you pronounce your last name.
Thank you, Chief Justice Kadish. Kannon Shanmugan for the N.F.L. Appellants.
Okay, great. So you have 15 minutes of argument for your side. Would you like to reserve any time for rebuttal?
I would, with the court's leave, 3 minutes, please.
And so what'll happen is it still counts down from the full 15 minutes. When it gets down to 3, the yellow light will come on. There'll be a tone that you'll hear, but the clock keeps running as long as you're still standing there.
Great. Thank you very much.
Go ahead.
May it please the court. In this case, former Raiders coach Jon Gruden brings unsubstantiated claims against the NFL and its commissioner, claiming that they are somehow responsible for his resignation after the publication of racist, homophobic, and misogynistic emails that he wrote and broadly circulated, emails that are too vile to read out in open court. But when Gruden entered into his contract with the Raiders, the richest coaching contract in NFL history, he agreed to 2 broad arbitration provisions that cover all disputes arising out of his employment agreement or involving conduct detrimental to the league. The district court erred by refusing to hold Gruden to either of those provisions and to send his claims to arbitration. Now, in particular, the arbitration provision in the NFL Constitution, which was unambiguously incorporated into Gruden's employment agreement, covers the claims in this dispute, and it is neither procedurally nor substantively unconscionable. Gruden's contrary arguments, embodied in a draft order that the district court simply adopted wholesale, lack merit, and they ignore both the Gruden represented that he had read the NFL Constitution and that Gruden was the very definition of a sophisticated party. Having settled his claims with the Raiders for an undisclosed sum, Gruden now seeks an additional payday for his reprehensible conduct. Settled law requires that his claims be sent to arbitration, and the district court's order should therefore be reversed. Now, with the court's leave, I'd like to start with the NFL Constitution, because I think that the easiest route to a reversal is to say that that arbitration provision applies here. Now, to begin with, Gruden does not seriously dispute that his employment agreement with the Raiders expressly incorporated the terms of the NFL Constitution, and you'll see that at pages 48 to 49 of Appellant's appendix. Indeed, what is more, in the agreement, Gruden affirmatively represented that he had read and understood the Constitution.
In that provision of the Constitution, though, counsel, it doesn't reference disputes with the commissioner himself.
So Article 8.3E, and this is at page 85 of the appendix, contains no limitation concerning the parties at all. So the relevant language is that the commissioner has jurisdiction to arbitrate any dispute involving ... any employees of members of the NFL that in the opinion of the commissioner constitutes conduct detrimental. So I will acknowledge that one difference between the provision in the NFL Constitution and the provision that is actually in the employment agreement itself is that the latter provision does contain that limitation. That's why we need the doctrine of equitable estoppel with regard to that provision. Here, by contrast, we don't need that because there is no limitation in the provision itself.
But by its terms, 8.3E does not reference the commissioner except as the arbitrator or the NFL. It's quite specific about members of the league, any players or employees of members of the league, or any combination thereof. But missing from that list is the commissioner and the NFL.
So again, our view is the relevant language is any dispute involving any employees. And so what we believe that that means, and I don't hear my friend Mr. Hosmer-Henner to dispute this, is that by its terms, once you have as one of the parties to the dispute an employee, the provision itself is triggered. Again, there is
So
no.
would this apply if there were a contentious divorce that involves scandalous allegations involving things that occurred while a player was playing for the league?
So it would require a determination by the commissioner that the conduct at issue be conduct detrimental to the best interests of the NFL or professional football. Now, as your honor may be aware, there will be circumstances in the disciplinary context where there will be conduct detrimental determinations based on the conduct of players off the field as well as on the field. But that is really the limitation here, is that it must be conduct detrimental to the best interests of the NFL. Now,
As
the
a
other thing.
practical matter, how does it work for the commissioner to be a party to the dispute and the arbiter of the dispute?
So that goes, Justice Bell, to the question of substantive unconscionability. And I would say two things about that. First, that this court need not reach that question once it concludes that the provision in the NFL Constitution applies, if it agrees with us that there is no procedural unconscionability. And here I think the case on procedural unconscionability is quite clear. I'm certainly aware of no case in Nevada where a $100 million employment agreement negotiated by an expert agent has been held to be procedurally unconscionable.
Well,
And
but
under
counsel, what about due process? I mean, to have a dispute with somebody who's the one deciding the dispute, seems like there might be a problem there.
Yes, so if the court were to reach the issue of substantive unconscionability, I would make 2 points about the possibility that the commissioner would be the arbitrator. First, that in the context of sports leagues, there is substantial authority for the proposition that it is okay for the commissioner to act as arbitrator, even where the commissioner is reviewing his own handiwork in the disciplinary context. Mr. Hosmer-Henner in his reply brief doesn't address any of that authority. We cite decisions from the Second Circuit, the Eighth Circuit, and elsewhere. But I think, Chief Justice Cadish, my second point would be that under this agreement and under the dispute resolution procedures, which Mr. Gruden himself attached to the filings below, the commissioner has the authority to designate someone else to serve as the arbitrator. So if the commissioner decided to be the arbitrator here, and I would expect that he wouldn't under these circumstances, but if he were to make the decision that he would designate himself, that he would proceed as the arbitrator, of course, he would potentially be exposing himself to a challenge if he were to issue an arbitral award that he was acting out of bias. That's one of the familiar bases for challenging an arbitral award. But our submission is that for purposes of substantive unconscionability, that's kind of an unripe consideration here because the commissioner could designate someone else to serve as the arbitrator. If you look at the cases we rely on, in many of those cases, the commissioner in fact has done so. And that would alleviate any concern about bias. Now, again, there's no independent constitutional challenge here. The only relevance of that in Mr. Hosmer-Henner's brief is to substantive unconscionability. And again, the court only gets to that if it concludes that there is procedural unconscionability here. So we would submit that the straightest line to a reversal here is to say two things. First, that the NFL Constitution arbitration provision applies. And one last thing I would say to Justice Pickering on the issue of kind of an outlandish hypothetical, something that has nothing to do with employment, is that it is certainly true that there is one other significant limitation, and that is, the limitation that when you're talking about a situation in which the contract has been terminated, the claims at issue have to have their roots in the contractual relationship. We are in agreement with Mr. Gruden that that is a fundamental principle of California law. Now here, of course, the dispute itself involves the alleged infringement of rights under the contract. Some of the conduct at issue, the alleged leaking of the emails, obviously took place during the contractual relationship. So this is an easy case with regard to that, relatively generous.
Could Mr. Gruden have moved to compel arbitration against the NFL and the commissioner under this clause as worded?
This clause as worded is bilateral in that regard. So again, any dispute involving any employee of a member of the NFL, if he wanted to compel arbitration, he is a party to that dispute. And so by its terms, that provision would be triggered. Now, it would have to be conduct detrimental to the best interests of the NFL. And if the commissioner made a determination that the conduct at issue did not qualify, then of course, that requirement would not be satisfied. And there are other subparts, as you will be aware of Article 8.3 that don't
Yeah.
contain that limitation.
But I mean,
So-
you could read Article 8 read as a whole to say it reaches disciplinary matters and that 8.3E is a catch-all, but that it does not include the commissioner and the N.F.L. because while it lists everybody else, it doesn't list them.
So there is no such limitation on the face of Article 8.3 to disciplinary proceedings. And so this would work the same way. And of course, if you look at some of the other subparts, let's say you have a dispute between two teams, that would not typically involve disciplinary proceedings at all. And yet that would be triggered potentially by other parts of 8.3 and also potentially by 8.3E as a catch-all.
Well, but 8.3A would seem to capture that, any dispute involving two or more members of the league.
Correct. My point is simply that Article 8.3 as a whole is not limited to the context of disciplinary proceedings. And 8.3E does not contain that limitation either. Now, obviously, we also rely on the provision in the employment agreement. And while that provision by its terms does contain the limitation to disputes between, in this case, Gruden and the Raiders, the whole point of the doctrine of equitable estoppel is that there are circumstances in which third parties are able, notwithstanding textual limitations, to invoke arbitration provisions where there is a close relationship between the claims and the underlying contract. And our fundamental submission on that is that when you look at the California cases like Boucher, those are cases where when you have claims that presuppose the existence and the validity of a contract, as was the case in Boucher, and in addition, whereas here the contract is concededly the primary source of the damages.
But in Boucher, both the employer and the successor to the employer were co-defendants on the claim, right?
That is correct. But I think that Boucher's reasoning was a sort of claim by claim analysis. And in Boucher, as in this case, you had claims for intentional interference with an existing contract and prospective contractual relations. And in addition, equitable estoppel applies where the signatory alleges substantially interdependent and concerted misconduct. And we think that here, too, that is the case. I do want to emphasize—
There wasn't a breach of the employment contract itself that's being asserted, right?
No, and of course you would rarely, it's hard to imagine a situation in which that would be true where you have a third party. But Justice Bell, I think what I would say
that's virtually every California case on where they've found equitable estoppel, right? There's a third party that's tied to a contract where there's a breach of contract and a claim against the third party.
It is certainly true that in Boucher, you were dealing with a defendant who was in some sense a successor. But again, I think when you look at the claims themselves, they were claims like an intentional interference claim, elements of which are the existence and validity of a contract. And one other thing I would say, because I see that my time is rapidly expiring, Justice Bell, is that in some sense, this is a very artificial case. Because but for the fact that for whatever reason, the Raiders settled out of this case and paid Coach Gruden an undisclosed sum, this would be a case where we would be operating alongside the Raiders. And to the extent that Chief Justice Cadish, you're troubled by the fact that this happens to be a case where the commissioner is a party and is the potential arbitrator, I would say that there is no meat on the bones of the allegations that the commissioner was somehow involved in this conduct. It is telling that my friends on the other side are now attempting to supplement the record with articles from ESPN to buttress allegations in the complaint that are completely threadbare. And I would respectfully submit that that creates the inference that this is artful pleading in order to try to create an unconscionability problem with the provision, which would obviously not exist but for the fact that Commissioner Goodell was named as one of the parties. And I see that my time is slipping away, so with the court's leave, I would reserve the balance of my time. Thank you.
Counsel.
Chief Justice, and may it please the court, Adam Hosmer-Henner of McDonald-Carano on behalf of Respondent Jon Gruden. There is not a presumption in favor of arbitration when there is not a valid and enforceable contract. Appellants asked this court to reverse Judge Off on the basis that there was a buried paragraph in a 450-page document that Respondent never saw, couldn't negotiate, and had no opportunity to modify, while the N.F.L. reserved the unilateral ability to change that NFL Constitution.
Did Mr.
And it's-
Gruden not have counsel representing him when he agreed to the contract?
To my knowledge, he did not, Your Honor.
He did not.
He did not.
He negotiated this contract with the Raiders without counsel to
There-
review it.
Your Honor, there's nothing in the record indicating that he had counsel present when he signed it or that it was explained to him. He had his agent with him, and that's the only piece of evidence in the record. These contracts are negotiated in a matter of hours. And what's important here is that that's a factual finding that the district court made that appellants have not been able to challenge. And that is that he was never provided a copy of the NFL Constitution. And nothing in the record establishes that the
represents in the contract that he read it.
He does, and under California law, that mere representation is insufficient, even if the party represents that they've read the employee handbook or that they read the NFL Constitution. That doesn't show that the lack of an actual opportunity to read those terms, especially when there's no indication that that 450-page document contained an arbitration clause that would affect his substantive rights, that he should have been reading that contract and been aware of it. This is a very lengthy document that is not relevant to Coach Gruden on a day-to-day basis, and that the undisputed testimony below indicates that he didn't receive. But even if he had received it, or some version of the contract, what the NFL parties failed to do was meet their burden to show that the document they introduced was the document that Jon Gruden was provided or that was in effect at the time that he signed his agreement. The only evidence in the record is a generic statement from an NFL attorney saying that attached as Exhibit 3 to the motion is a true and correct copy of the Constitution and bylaws of the NFL. They stretched that to mean that that Constitution was in effect at the time of this employment agreement. They easily could have put in that submission into the declaration. But just as in the Flores
Counsel, are you familiar with our case regarding Uber and Airbnb, where when you download an app, you've agreed to an arbitration provision, and we have found those enforceable?
Extremely so, Your Honor. And in those cases, even the browser wrap and the click wrap type cases, that arbitration clause still has to be available to the individual. So the Blizzard case is one of the cases that was cited from California. And in that case, even if it's the bare minimum where you're scrolling through a browser wrap, it still has to be available to you.
Right.
This document was not. It was not provided to him at the time. And there's a difference here.
That's the difference between not provided to him and not available.
Well, the difference here, Your Honor, is that this could have been available, and they make the speculation that Coach Gruden could have easily requested that from the Raiders. Possibly could have, but it's their burden to show that this document was the one in existence at the time he signed it. In the Flores decision, you had an equally kind of concerning situation where they introduced a version of the document that wasn't signed. And the Southern District of New York said, you failed to meet your burden at the first stage. All you had to do was to show the executed version. They ultimately introduced that upon reconsideration. The court said it's too late. And that's what we have here. It's simply too late for them to introduce the testimony that they said that their witness would testify to. So even if you reviewed some version of the contract, that doesn't mean you reviewed the version and that this version was in effect at the time he signed the agreement. The other factual issue that's dispositive here is that there's no evidence in the record that Commissioner Goodell has issued an opinion that that this dispute involves conduct detrimental to the league. This is not a dispute and not an arbitration clause where the dispute is arbitrable if it involves conduct detrimental. That is not what Section 8.3E says. Section 8.3E only covers disputes where it is the opinion of the commissioner that the conduct is detrimental. If this is a situation where a substitute arbitrator is provided or the commissioner delegates it to another arbitrator, in the event that happens, that subsequent arbitrator doesn't decide the scope of the arbitration clause in the event that there is over the issue of whether the conduct is detrimental to the league. That arbitrator is limited to the decision of whether it is the opinion of the commissioner that the conduct is detrimental to the league. That clause has never been enforced in a situation like this, and nor can it be enforced because it's wholly illusory and one-sided. It would allow, in response to some of your hypotheticals, the commissioner to determine that a private divorce proceeding involved conduct detrimental and thus was referred to arbitration, that a sexual harassment charge against a member of the league involved conduct detrimental. And without any ability on the other side to buy into that proceeding or to have awareness in advance that that was going to be subject to arbitration, decide in their unilateral and unfettered discretion that the conduct is detrimental to the league and therefore referred to arbitration.
Can you talk about the language of the clause itself? Let's assume for a moment, and I realize it's contrary to your position today. If we assume for a moment that section 8.3E of the NFL Constitution is in effect, does the language itself apply to this dispute? Like if your client were bound by it, let's assume for a moment he's bound by
Sure.
it.
If he was bound by that particular language, the answer is no, because there is not an opinion of the commissioner that says this conduct is detrimental. And one of the arguments they make is that it's possible for the
But
dispute.
let's pause. I want to pursue what Justice Cadish is getting at, which is, let's assume that he was delivered a copy of the Constitution at time of signing, and further, that we will equate the filing of the motion to compel by the commissioner and NFL as an ipso facto determination that what's involved here is conduct detrimental. So we clear both those two hurdles. Does, by its language, does 8.3E apply? Why or why not?
One, because it only applies to current members of the league, and we don't think that the NFL Constitution should apply to former members indefinitely in perpetuity. Number two, it doesn't apply because there has been no factual predicate that the commissioner has issued an opinion that this is conduct detrimental. How it's supposed to work, Your Honor, is a situation where there is some notice and hearing, some amount of due process, and in the course of those internal proceedings, the commissioner issues an opinion or a fine saying that this particular conduct is conduct detrimental to the league, and I assess a fine of a certain amount. Absent that due process, absent that notice of a hearing, there's no factual predicate on which we could pursue an arbitration, given that it only applies to the opinion of the commissioner.
But if the commissioner had made such a finding that either the commissioner's conduct in allegedly leaking the emails or Gruden's comment in writing them, one or the other or both constituted conduct detrimental, would there be any impediment to this proceeding in arbitration?
If that finding had been made by the commissioner in accordance with due process and in accordance with a notice of a hearing, then it would be within the scope of that clause. We still believe that that would be an illusory clause and that the NFL Constitution would not be an appropriate contractual obligation for Coach Gruden because he didn't execute it. He's not a party to it. And as the Southern District of New York found in Flores, that contract's illusory because it can be modified in the sole discretion of the commissioner and the
But the
NFL.
contract that was not enforced in Flores was equivalent to the Raiders contract here, and it had not been approved by the commissioner as is required for that contract to take effect. That's different from the incorporation by reference of this provision. And in fact, they deemed this provision incorporated in the other properly executed contracts, right?
One of the contracts in Flores was decided on a basis. The other one, they found the NFL Constitution in this particular provision had not been validly incorporated because it was an illusory contract, because the NFL parties retain the unfettered discretion to modify the NFL Constitution. And on that basis, and in the Graham and the Bacani decision that we cite in our briefs as well, when there is nothing exchanged, when a party gets nothing from the briefing, then that contract is illusory and the party cannot enforce it like the NFL cannot enforce it.
And that was under Massachusetts law or Florida law or something?
That was under Massachusetts law in the Flores decision. And what we cited are the two California cases, Graham and Bacani, illustrating the same principle. That especially whereas here, where there's no obligation upon the NFL, as it's not a contracting party under the NFL Constitution, doesn't have those same exchange of bilateral promises with Jon Gruden in the NFL Constitution. They're not a counterparty. That contract would be illusory and would lack the modicum of bilaterality that's required for any arbitration agreement. And that's specifically important here.
But that's for substantive unconscionability. And he makes the point there's no procedural unconscionability here.
And we disagree with that, Your Honor, because one of their own arguments is that every coach in the NFL has to accept the NFL Constitution in order to coach in the league. That at a minimum would establish the adhesiveness of the contract that would be sufficient under Armendariz and the other California decisions to establish the bare minimum procedural unconscionability. Moreover, where a much larger contract is incorporated by reference,
Every contract of adhesion isn't automatically unconscionable, right? That's not your position today, is it?
Our position is not that every contract of adhesion is unconscionable. Our contract is that where there is an issue with the contract of adhesion with unequal bargaining power and where one party reserves a take it or leave it type contract.
How is there unequal bargaining power?
Coach Gruden had no opportunity to negotiate the NFL Constitution. He couldn't request a modification of it. He had to comply with it in order to get the job that he has trained his entire life for. That is his career. And in order to perform his career and accept a job in the National Football League, he had to accept the NFL Constitution, unmodified with no changes whatsoever.
Or he could have worked for ESPN, apparently.
Or he could have worked in a different profession. But under California law, working in a different profession under the Amway cases that we've cited, that's not sufficient to find that a contract isn't unconscionable. And the Amway cases are especially instructive because there, the contract and the arbitration provision provided that the parties had to choose a specifically trained arbitrator from Amway. And Amway had trained these arbitrators. They were through jams, but they were trained by the company itself. Here, it's much, much worse than that because Coach Gruden is required to arbitrate in front of the very parties that he is suing. They're the defendants in this action. And this idea of that there are conclusory threadbare allegations has already been tested by fire in the district court, and we've prevailed, showing that those allegations are more than sufficient under Nevada's notice pleading. We supplemented only to provide additional background, not because there was any defect, and that also is not on appeal, as the district court's decision found conclusively that every one of our claims survived. I want to quickly talk about equitable estoppel, because the equitable estoppel doctrine has two steps. One is that when there's the facts and circumstances have to be intertwined, and there has to be some fundamental fairness for why a party is attempting to argue for some benefits and some terms of the contract, but then deny the other portion of the contract related to the arbitration. That's not the case here. In Boucher, the claims involved a breach of contract, failure to pay wages, and were against two essentially joint employers. They didn't specifically analyze a tortious interference claim. Gruden's claims do not rely upon any term of the contract. There's not any provision that he's attempting to enforce against the Raiders, against the appellants here, or against any other party.
Well, but the dominant prayer for damages is predicated on his $100 million contract with the Raiders. So it is intertwined, akin to Boucher, I think.
I would disagree because it's a function of damages rather than a fact of his claims.
And he's also, isn't he alleging also negligence in the commissioner's supervision of the people who did the investigation that resulted in the leaks?
That's correct. And that's not intertwined with his employment contract with the Raiders. In fact, it has nothing to do with them, and it's entirely separate and distinguishable. What Boucher talks about is and the other cases, the Forever 21 case as well, talk about situations where a party is attempting to enforce the fundamental aspects of their contract, but in the guise of a statutory claim. So a failure to pay wages or some statutory violation of an employment law. Not here, where the Raiders could not have worked together with the NFL parties. There's no allegation that they did, and the claims are entirely separate and distinct. We are not bringing a claim for wrongful termination. We are bringing claims for tortious interference from the external actions that the NFL parties took, the leaking of the emails and the pressuring of the Raiders, which is a separate and distinct action from the wrongful termination of the contract by the Raiders. That organization was as much a victim as Coach Gruden was here because they received the unlawful influence and pressure from the NFL parties, rather than being a co-conspirator or someone that we could have possibly named for the same conduct. But on equitable estoppel, the most important thing is the second step, which is even if you are equitably allowed to enforce and invoke the contract, it still has to match the terms of the contract and the scope of the arbitration clause inside that contract. Appellants haven't provided a single authority where a party has been able to expand the scope of an arbitration clause beyond what the parties agreed to, because that would allow them that would force a party to contract and arbitrate a dispute that they didn't agree to arbitrate within that specific arbitration clause with the other party. This clause was limited solely to disputes between the Raiders and Gruden, and the NFL parties cannot expand that in their own self-interest. Unless there are any other questions.
Nope.
Thank you very much.
Thanks, counsel.
May it please the court, Chief Justice Cadish and Justice Pickering, both of you asked Mr. Hosmer-Henner whether he was arguing that there is any limitation that would apply here in Article 8.3E. And he conspicuously did not take that invitation and suggest that there was. And I think that that was for good reason. When you look at the language of 8.3E, all that is required is that one of the parties be an employee. The provision itself, of course, refers to the league. And all of this, of course, has to be interpreted against the backdrop of the presumption in favor of arbitration, which would, of course, resolve any doubts about the provision's scope. Mr. Hosmer-Henner instead focuses on the validity of the incorporation. But with all due respect, this suggestion that Coach Gruden should not be held to the terms of the NFL Constitution is disingenuous. If you look at his own declaration at page 575 of the appendix, he does not walk back the contractual representation that he had read and understood the terms of the Constitution. And there is no requirement that the NFL affirmatively provide a copy of the Constitution. Justice Pickering, as you pointed out, the legal standard is whether the incorporated document was known or easily available. And Mr. Gruden himself argued to the district court that the Constitution was readily available on the internet. And Gruden was a longtime NFL coach who is presumably very familiar with all of the rules of the game, which are contained in the Constitution and bylaws.
I think his lawyer argues it was hard to find on the internet.
If you type NFL Constitution into Google, it is the first search that comes up. But again, I'm happy to sort of rest on the fact that there was no request here and that he affirmatively represented that he had read it. The version that was introduced indicated on its face that it had not been amended. And with regard to the conduct detrimental determination, it's enough that the commissioner, by moving to compel arbitration, had made that determination. And at a minimum, he could make it in the arbitration as a delegated issue. And with my remaining 10 seconds on the issue of procedural unconscionability, all that I would say is that Chief Justice Cadish was exactly correct. The mere fact that something is a contract of adhesion is not enough. And here, what we're really talking about is a single term that in Mr. Hosmer-Henner's view, the Raiders would not have negotiated away. No surprise there, because the incorporation of the Constitution is central. It contains the rules of the game. And it's faintly preposterous to suggest that a longtime coach who is represented by a savvy agent should not be held to those terms, including the arbitration provision. We would submit that the district court's orders should be reversed. Thank you.
Thank you. All right. All right, thanks, counsel, for your briefs and your arguments. This matter will stand submitted and will be at ease for a few minutes while we reset for our next argument.